Our Chief Justice is Oliver Ellsworth, and our Supreme Court case is Plessy versus Ferguson by Ana and Maddie.
Oliver Ellsworth was born on April 29, 1745, in Windsor, Connecticut, to Captain David and Jemima Ellsworth. He entered Yale in 1762 but transferred to the College of New Jersey, now known as Princeton, at the end of his second school year. He studied theology and then law. He was a lawyer, public security interest, lending and investments, and mercantilist. In 1777, he became Connecticut's state attorney for Hartford County. He was in the state upper house. He served on the Connecticut Superior Court, the Council of Safety, the Committee of Pay, the Continental Congress, the Confederation Congress, and he wrote letters influencing the adoption of the Constitution. He played a major role in drafting the Judiciary Act in the first Congress as Connecticut's first senator from 1789 to 1796. He was Chief Justice of the Supreme Court from 1796 to 1798. He was the most underrated founding father and played an active role in the Constitutional Convention. He also resigned from the Supreme Court due to health issues. George Washington appointed him Chief Justice of the Supreme Court in the spring of 1796. He also served as Commissioner to France in 1799 and 1800. His most controversial opinion was United States versus Isaac Williams in 1799. Oliver died on November 26, 1807, in Windsor, Connecticut.
Our Supreme Court case is Plessy versus Ferguson. The people who were involved in the case were minorities against the city of Ferguson, and the case happened on April 18, 1896. The case originated in a New Orleans court. The case stemmed from an 1892 incident in which an African-American train passenger, Homer Plessy, refused to sit in a car for blacks. Rejecting Plessy's argument that his constitutional rights were violated, the Supreme Court ruled that a law that implies merely a legal distinction between whites and blacks was not unconstitutional. As a result, restrictive Jim Crow legislation and separate public accommodations based on race became commonplace. Plessy versus Ferguson went to the Supreme Court because when Plessy was convicted of violating the law in the 1890s, he filed a petition against the judge, taking it to the Louisiana Supreme Court. The Plessy versus Ferguson ruling, which indicated that the federal government would officially tolerate the separate but equal doctrine, was eventually used to justify segregating all public facilities, including railroad cars, restaurants, hospitals, and schools. However, colored facilities were never equal to their white counterparts in actuality, and African Americans suffered through decades of debilitating discrimination in the South and elsewhere because of the ruling. In 1954, Plessy v. Ferguson was struck down by the Supreme Court in their anonymous ruling in Brown v. Board of Education of Topeka. The final decision made by the Supreme Court was made on May 18, 1896. The impact which Plessy v. Ferguson made on American society was that Plessy set the precedent that separate facilities for blacks and whites were constitutional as long as they were equal. The separate but equal doctrine was quickly extended to cover many areas of public life, such as restaurants, theaters, restrooms, public schools. The Supreme Court of the United States determined that if legislation made distinctions based on the race but not deprive anyone of rights or privileges, it is constitutional. The Supreme Court seemed to believe that the common practice of separation was an inconvenience, not something that abridged the rights of African Americans. The court also presumed that the legislation was powerless to do away with racial instincts or to abolish distinctions based on physical differences.